This is You and the Law on AM 650. Now back to the show.
On this episode of You and the Law, we're talking family law with our guests from Lindsay Kenny, LLP in Vancouver and Langley, as it turns out. Angela Thiel is a partner with Lindsay Kenny in Vancouver. Puneet Kara is an associate with Lindsay Kenny in the Langley office. And Puneet, you're right in the middle of talking about parenting arrangements. And I asked during the break of both of my guests, is this the area in family law in which the most fighting takes place? And they both went immediately, oh yeah. So continue on here, Puneet, because obviously, and we just determined before the break, the courts are only allowed to care about the interests of the child. That's it. That's their criterion. So with that in mind, how do decisions get taken with respect to the divvying up of the sharing and all of those other arrangements?
Like I said initially, as long as both parents are okay parents, they need to be working on having as much as time with the children and with the criteria that it remains in the best interest of the children to be with both parents for the maximum time.
Right.
So that is the starting point. However, there are practical considerations that need to be taken into account. For example, if the child is very young, for young children, you don't want the child to be away for more than more than 7 days. That's too long of a time away from each of the parents. So in those circumstances, you have something called a schedule which is commonly used called the 5225 schedule. And what I mean by that
These are days, right?
Yeah,
Numbers of days?
Number of days. So
okay.
Basically, a parent would have the child from Monday to Friday for a period of 5 days. The other parent will have from Saturday, Sunday, followed by the next parent's turn from Monday, Tuesday, and then again the 5-day cycle continues. Why this is an interesting concept is because this way the parents share equally during the weekdays participation of the school and help children with their homework, take them for activities, and also rotate the weekends. So they get the downtime as well, where they can plan a trip, a day outing. So it's a good combination for parties to follow. That's one criteria. The other criteria would be something like work schedules, taking into account, there are professions such as nurses, police
shift
officers,
work, those sorts
exactly,
of things. Sure,
shift works, where they're working 4 days on, 4 days off, whereas the other parent is Monday to Friday, 9 to 5, regular job. So in that kind of situation, how does the parenting time work? Maybe the parent who has a regular schedule does not want to be, told every time to work according to the schedule of the shift work parent.
Sure.
So that becomes an issue of conflict, and that needs to be sorted out again with the criteria. How do we maximize the contact with keeping the parental schedules comfortable for both sides to follow?
How do these get resolved usually? Because and you're being all very logical and cool about all of this, but we both know, and I use the word fight deliberately during the break, there's a lot of emotion, there's a lot of acrimony, there's a lot of bitterness in all of this. So do the settlement of the parenting arrangements usually end up in court, or are you as lawyers able to resolve it prior to a showdown with the gowns on?
Again, it's a highly emotional
Absolutely.
subject, and like property settlements or even spousal support where you can do a cost-benefit analysis with the clients, you can't do that with the children.
Sure.
So if a parent feels very strongly about certain concerns about the children, then that issue may need to be litigated. However, as lawyer, we will try and first of all tell nobody has, or none of the parent has a de facto right to have all the parenting time. That's not going to happen. So you need to work with sharing the parenting time in as much as possible, keeping the work schedules in mind, keeping how they're going to afford daycare, because if the other parent is staying home, why not have the children stay with the other parent then
instead of paying daycare?
Exactly,
sure.
Daycare. However, it becomes really convoluted when the incentives are different. Sometimes the parents have an incentive for reaching the 60-40% split, because what happens with that is the child support, then the child support obligation gets reduced. It's the set of child support that needs to be paid as opposed to the full child support.
Okay.
So those are the incentives for the parties to actually fight for greater time without really looking into the criteria, what really is working for the children, and that can be problematic. And those are the cases which might need to go to court because you want the judge to look through it and tell the other parent, sorry, if
Right.
you're going to put the child, you're going to be working all the time and you're putting the child in daycare, whereas the mother is present home and she's been, the primary caregiver of the children.
What's the point?
What's the point?
Right,
Right. So
exactly.
those are the kind of situations I think will need to go to court if one of the parties is very head-bent on not understanding the nuances of how to raise the children.
Sure. Angela, I wanted to ask you about, and this is something that comes up a lot, and we hear about it. You read about it in the papers all the time, and certainly on the news. One parent, again, with the bitterness and the emotional volatility that accompanies all of these breakups of marriages and relationships, one parent alleges child abuse of the other parent. Whether it's on the advice of a lawyer or just a mean-spirited thing, this guy is not going to get custody of those kids. I just feel that strongly about this. It's just so I'm going to allege that he has molested these children. Even if the guy's never laid a glove on them, except as a loving parent. It's a tactic, and it's a nasty tactic, and yet it gets used.
Well, the first thing is, sadly, it does get used, but also sadly, it often is someone that genuinely believes. It's less of a tactic as sometimes people convince themselves. And both Puneet and I have had different long trials about, did he or didn't he?
Yeah.
So the first line of defense is there are a number of psychologists and experts in this city who come in and they interview children and they report to the court.
Okay.
And judges make their decisions based on those reports probably 90% of the time.
All right.
Or you get that report before your trial starts and say, look, this judge is probably going to do what this expert said. The case that I had, which was a long trial and probably 2 years that Dad didn't see the little girl, the family, the mother was strongly religious, and she noticed behavior in a young child which in her mind shouldn't happen.
Right, okay.
The young girl was masturbating. She wasn't very sophisticated, so the concept that this does happen, and it's usually attention-seeking behavior, she just decided this had to do with Dad. She was supported in that by members of her church and her pastor, and as a consequence, it became a long, expensive, involved trial. My client couldn't have possibly afforded to pay for it.
Right.
He paid for part of it, and the rest was just, look, we just got to keep going here.
Right.
The ministry becomes involved, the Ministry of Children
Of course,
and Family Services.
absolutely, yeah, absolutely.
And of course, they're in a bind. They don't want the child to be at risk, so they will usually be very, recommend something fairly protective. And the court says, well, how do we know? And obviously, we want to be protective. And the consequence is sometimes people don't see their kids for 2 or 3 years.
Yeah.
And ultimately, that case resolved after a lengthy trial in which, a judge, a very good judge, had to go through an awful lot of evidence and listen to a bunch of people and make a decision that this didn't happen. My client in that case had passed a police polygraph, and but the law is, in terms of those type of situations, as to when you can accept a polygraph as evidence that someone didn't do it, it's difficult.
So a lot of what you do acting in family law matters is diffusing situations, cooling people off. And I imagine that's a real chore in a lot of cases.
Well, it's not the easiest job, and it's what really is sometimes quite distressing is you'll hear members of the public saying, well, it's the lawyers just making these people fight because they just want to make money.
Right, yeah, keep that meter running.
And, I often have people come in and they will, indicate they want to fight, and I'll say that's, I don't think you're going to win this fight. And it's not uncommon to see them go down the road to somebody else and read the reasons for judgment later and think, well, they didn't win that fight, and I wonder how much that costs. So
right.
If you go through your practice trying to be ethical and reasonable, that's all you can really do. And if you keep being objective, you help people a lot more than if you just become their champion and ride up, with your sword, because, you can't tell people they're going to win.
That's right. We have to leave it there. Unfortunately, we're fresh out of time. We do thank you both for coming in. If you would like to contact either of my guests, go to lklaw.ca is Lindsay Kenny's website. All the contact information is there, and they would prefer an email. Thanks for being with us on this episode of You and the Law.